Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there's really no substitute. As legal practice becomes increasingly international, keep ourselves ahead of the curve with our relationship with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 50 Asian and European countries.
We believe in partnering with our clients, protect and grow business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Everybody, thank you for joining us for today's online talk entitled From Judgment to Payment, Navigating Execution Proceedings. My name is Manwei. I'm a partner with Ma Wing Kwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dr. Ma Wing Kwai. Our legal team today comprises of 30 over lawyers and a support team of 19. Dr. Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm, a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, dedicated employment and industrial relations team, and also a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talks series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which are also broadcasted live. But since the COVID-19 MCO, we have moved online in order to continue with the objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Now, before we continue, please be reminded that this talk is not legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Allow me to introduce our speakers for the day. Our first speaker will be Ms. Alyssa Dalila. She is one of our associates. She's an associate in our dispute resolution department, and she holds a Bachelor of Laws honors degree from International Islamic University, Malaysia. Alyssa was admitted to the Malaysian bar in October 2023. Her areas of practice include general and commercial litigation and family law. Our second speaker will be Ms. Amanda Pond. She is a paralegal at our firm. She is currently in our dispute resolution department. She also holds a Bachelor of Laws honours from Cardiff University, UK. She was called to the English bar in 2023 and was also admitted to the Malaysian bar as an advocate and solicitor in 2024. Amanda's areas of practice include general litigation, land disputes, debt recovery, and family law. These are our top points for today. Alyssa will be speaking on what are execution proceedings, judgment debtor summons, and Garnishee Proceedings. Amanda will then talk about writ of seizure and sale and bankruptcy and winding up. We will then conclude with a Q&A session. If you have any questions, please don't forget to post it in the Q&A chat box provided. Now over to you, Alyssa.
Hi, good afternoon, everyone. I'm Alyssa, and I will be starting the talk today. So I will be covering three things. I will talk about and I will introduce what are execution proceedings. I will talk about judgment debtor summons and also garnishee proceedings as the execution forms today. So what are execution proceedings? Let's first look at the process of a standard claim. So usually when clients come to us and they tell us, we have a debtor or somebody who owes us money based on an agreement and things like that, usually what will happen is a letter of demand will be issued. So this letter of demand will give the debtor some time to, either respond or don't respond. And what happens next will be a filing of suit. So after you file a suit, you will obtain a judgment. And this judgment, the judgment against the debtor. So what we want to focus on today is the enforcement of this judgment. So let's say you obtain the judgment orders your debtor to pay an amount to you or to proceed to do something based on that judgment, but they don't do it or it takes some time and they default. So what happens after that? And what can we do to make sure that at the end of the day, you receive or you recover the amount that you have sought before? That's what we're going to be talking about today. So basically, execution proceedings deal with the procedural steps taken to enforce a judgment. So the procedure and the modes, they're governed by the Rules of Court 2012. And there's various modes of enforcement of judgment, which we will be speaking about today. But we need to understand, first and foremost, what is a judgment and, how can we ensure that what we have is something that can be enforced. So the Debtors Act 1957, Section 2, specifically states that a judgment includes any decree, order, or decision for the payment of money. So it covers a lot of types of judgments that you can receive, which can be enforced. So the mode of an enforcement proceeding or execution of the judgment will depend on the type of judgment that the plaintiff has obtained from the court. But there's payment of money, there's possession of immovable property, delivery of movable property, doing or abstaining from doing an act, or requiring an act to be done. Most of the judgments that we'll be focusing on today involves judgments that require the judgment debtor for a payment of money. So in respect of judgment debts, so we're looking at Section 3 of the Debtors Act 1957. So basically, this section introduces or defines an execution in respect of judgment debts. So it says that any sum of money payable under the judgment of a court may be recovered in case of a default or a failure of payment. So that outlines it very clear that there needs to be a default or a failure of payment where you can thereafter execute that judgment against the judgment debtor. So who is a debtor or who is a judgment debtor? So a judgment debtor is a party who has been legally determined by the court to owe money to the opposing party. So if you are executing the judgment, then you are referred to as the judgment creditor and the opposing party is the judgment debtor. So it doesn't matter if the person who would like to execute the judgment is considered as the judgment creditor, and moving forward, we will call the debtor as a judgment debtor. So the first mode of execution that I would like to focus on is called a judgment debtor summons. So a judgment debtor summons is basically an application to the court for the discovery of information on the assets and the financial means of the judgment debtor. So through a judgment debtor summons, we're able to discover whether the debtor is able to pay or to satisfy the judgment debt. So briefly, what will happen is that the court will examine the individual or the director, if the judgment debtor is a company, by asking them to disclose information such as their bank accounts, their assets, and their source of income, such as their salary or their business revenues. So when the court has this information, then the court can order the judgment debtor to pay the judgment sum, either in one lump sum or in installments. So the procedure is fairly quick. You file the papers, there's a hearing date, and then you serve the cost papers, and then you get to the final hearing. However, it is a bit tricky in terms of the technicality of a JDS procedure in that the service of the cost papers must be a personal service. What this means is that your debtor will have to sign or acknowledge the receipt of the cost papers personally. It cannot be left at their office or at their house. They will have to personally sign for it. So a failure of this personal service would probably prolong or extend the waiting time for you to be able to recover the money that you are seeking. So after you have the hearing date, briefly, there are two situations that might occur depending on your debtor. So if your debtor is in attendance, then we will do the examination and you will receive the order. However, if your judgment debtor is not in attendance or is uncooperative, which is, I would say, quite a number of times from our clients that we have received, then we might proceed to do things like an arrest warrant to compel the JD to attend the hearing, and then we will do the examination. I won't focus on, the nitty-gritty of the whole procedure, but just as an overview so that you may know what to expect if you were ever to do the judgment debtor summons. So what happens during an examination is we ask the JD questions on their monthly commitments or their financial standing, I would say. So if the JD, the debtor, is an individual, we ask them things like, what's your salary? How much do you spend on utilities, or how much do you spend on any school fees for your children? Things like that. So with that information in mind, and then the court will determine the amount that is needed to be paid by the JD. So let's say the JD owes you about 20,000 ringgit, and upon examination during the court, the JD says, oh, I make 30,000 ringgit a month, and minus all of my expenses, I do have about 19,000 left. So in that sense, the court will know after this examination that the JD does have the financial capability to pay the debt that they owe you. So then the court will then determine whether, this can be in lump sum, it can be 1,000 a month, 5,000 a month, depending on the discretion of the court, or it can be in lump sum if the court believes that the JD does have the financial capability to settle the whole debt. So once the court determines this, you will obtain your order. So for a JDS application, it is called a consent order, which is basically an agreement or a consensual agreement between both parties that this is how much that is going to be paid, either in lump sum or in installments. But what's important is that at the end of that order, it does say that if you do not comply with this order, you may be imprisoned. So it's stated in the order that, if you do not comply with this monthly installment or lump sum payment, then we might have to enforce to further charge this debtor with committal proceedings. This is something separate. And if you would like to know further, you are free to consult us anytime. But it is something that's after execution proceedings that I will not go into, but just for you to know. So let's talk about the pros and cons, or, in what situation would it be wise for you to proceed with the JDS application. So one thing about a JDS application is the procedure is fairly quick. An order can be obtained after one hearing, and usually the examination takes about, I would say, 1 hour. And it's also the most effective solution in scenarios where you, as the judgment creditor, that the JD has a working address or is able to personally receive the cost papers and sign for it. And this also means that it's better if you do have a debtor that is cooperative. So because they have to be able to attend the court hearing to be examined by the court. However, if your JD is uncooperative and does not want to attend the hearing, an order may still be made without the presence of the JD, but the JD still has to personally receive the cost papers beforehand, before the hearing can be done. So in that sense, the cons of a JDS is that if the JD does not acknowledge the receipt of the cost papers, let's say you've attempted to serve it 2 or 3 times, they're not at home, they can't sign for it, then the court may set additional hearing dates for you to further attempt service, which could lead to delays. And in some cases, the court may even order you to withdraw the application. So this would cause, further prolonging the matter. And it will cause significant, costs for you and also delays. And another thing is that even after obtaining the order, the JD may continue to default on the payment. And like I said before, we can do things like committal proceedings. However, this would incur further costs as it is a separate application. And again, imprisoning the JD may not necessarily lead to you recovering your debt, which is what you wanted to do in the first place. So that's some of the pros and cons that we can look at to consider whether JDS is suitable for your situation. So the next thing that I would like to talk about are garnishee proceedings. So garnishee proceedings are basically where a person may order a third party to essentially furnish the money to you. So it's a bit unclear. Okay, let's look at Order 49 of the Rules of Court. So it says that the court may order the garnishee to pay the judgment creditor the amount of any debt due or accruing due to the judgment debtor from the garnishee. I understand it's a bit confusing. So it basically just means that where there is a claim for money, as in you are the judgment creditor and that person is a judgment debtor, and the judgment debtor has money belonging or with a third party. So, for example, a bank. So this is an application basically to the court to attach monies owed from the judgment debtor's bank account to satisfy the sum due to the judgment creditor who is either due to the judgment creditor. So this is basically a third party. How I can simplify it is that you're basically asking the bank with which the JD has some amount of money to take that money and give it to you, essentially, basically. And this means that you are letting the bank know that this person has a judgment debt to you. They owe you some money. So this money is rightfully yours, according to the Garnishee order. So there's about 2 stages in a Garnishee proceeding. So the first stage, you obtain a Garnishee order to show cause to serve to the bank, the Garnishee bank, this Garnishee order to show cause. So then the Garnishee bank will enter appearance or respond to the order, stating that the JD has an account with them and confirming the debt. So maybe the bank will respond and say, yes, this person, this judgment debtor does have an account with us. So the money in the judgment debtor's account will be frozen or attached until the second stage where the order is made absolute. So then we move on to the second stage. In the second stage, which is the Garnishee order absolute, the court will now look at the responses from the Garnishee bank and all of the cost papers, whether they are in order, and the court will then grant a Garnishee order absolute, where the Garnishee bank will then be liable to make a payment to you as the judgment creditor by releasing the monies in the judgment debtor's bank account to the judgment creditor to satisfy your monetary judgment or your debt. So just to make it clear, you obtain a Garnishee order to show cause, you serve it to the bank, and then the bank will then, confirm whether there is an account and then confirm that if there is any contention from the bank, the bank wants to contest the debt, this is the time for the bank to do that. And if there is no contention on the debt and also the account, the JD's account with the bank, then the court will then grant the Garnishee order absolute, and the Garnishee bank has the obligation to release the monies to you, the judgment creditor, based on the amount in the judgment order that you got. So to make it easier, there's a case study, which is quite recent, is in 2023. This case is quite comprehensive, I would say, since it goes from the Sessions Court way up until the Court of Appeal. So in the Sessions Court, the judgment creditor served the Garnishee order to show cause to the Garnishee bank. And then the Garnishee bank stated that the JD does have an account with them, but the balance in the bank is only 9 ringgit and 81 cents. And this amount, pursuant to the order, they will freeze this amount. They will attach this amount. So because the amount is insufficient, because if I'm not mistaken, the actual judgment sum is about 200,000. The Sessions Court did not make the order absolute. So the action ends there. But then since the judgment creditor was not satisfied, they appealed to the High Court. And then the High Court ordered that the Garnishee order absolute should have been given. And this is because after the Garnishee order to show cause was given, and there was only 9 ringgit in the bank account, they found out that there were 3 additional sums that were put into the judgment debtor's bank account. And these additional sums were put in after the order was served onto the bank. So the bank, did not freeze these sums. However, the High Court held that there is a continuing obligation on the bank to continually freeze monies that may be credited. So even after the order was made and they found out there's 9 ringgit, but then there's 100,000 ringgit that was deposited after that, the High Court held that the bank does have an obligation to freeze this 100,000 ringgit in order to satisfy the debt. So this was what was held by the High Court. However, the bank sought leave to appeal on this issue to the Court of Appeal. And this is the final decision by the Court of Appeal, where the Court of Appeal ruled that the bank is under no obligation to continually freeze the amount in the bank of the JD. So if the order was given in June, and then the bank has this specific amount of time to freeze the money, so anything after the order that has been served, the bank does not have an obligation to attach or freeze the monies, only the funds in the account at the time. So, and future monies or future salaries also do not count. It has to be money that is currently in the judgment debtor's bank account at the time. So the Court of Appeal's decision is quite, I would say, groundbreaking, because it did overturn the High Court's decision. And, this would then mean we can now look at the pros and cons of a garnishee order. So we know that a garnishee order, if we do proceed with a garnishee order, it's easy because you don't have to deal with the judgment debtor. You are only dealing with the bank. And if you do have information on the judgment debtor's bank, which bank they use, maybe by way of previous dealings or payments, then you can strictly directly go to the garnishee bank of choice. And it will also give you direct access to the debtor's funds without the interference of the JD. So I understand, like previously in the JDS, you would need the judgment debtor's cooperation to attend hearings, to sign for the cost papers. But for a garnishee application, you don't need the interference or the cooperation of the judgment debtor. You only need to deal with the banks. And once an order is granted, you don't need a new lawsuit or a new action to now recover that money. You can use that same order to enforce the order and to receive the funds or to recover the money owed to you. However, it is in this same instance that one of the cons of a garnishee application is if you don't know your debtor's bank, then it might be difficult to identify the correct garnishee bank, and it could cause delays and your application could even be dismissed. And the second one is, as based on the case previously, it will only allow for the recovery of amounts that are within the debtor's bank accounts. So other specific assets that are not in the hands of the garnishee cannot be used. So like I said, if there's only 9 ringgit in the debtor's bank account, then you cannot proceed further because it will not satisfy, or you are not able to satisfy the full judgment sum. And also, a garnishee application will only focus primarily on liquid assets held by these third parties. So it does not provide a remedy for other forms such as property, real estate, or any other business assets. It's only based on the bank account. So we have had several times where a client has gone with a garnishee application that has been successful, but there's also been times where, like the previous case that I mentioned, there's only like 100 ringgit, 200 ringgit in the debtor's bank account. So when you get up to that point, it's a bit difficult to recover the full sum. So if looking at the pros, if you do have knowledge of the judgment debtor's bank account and you know that this judgment debtor has money, then a garnishee application would be the fastest way to recover any debt. So that's all from me. I will now pass the floor to Amanda.
Good afternoon, everyone. Thank you, Alyssa. Okay, so now today I'll be speaking on writ of seizure and sale, which is also another mode of execution of judgment. So essentially, writ of seizure and sale is an application that can be done by a judgment creditor to the court to seize properties owned by the judgment debtor. And then afterwards, if the judgment debtor actually has assets, then usually the court will continue to order to sell those properties and in regards to repay the judgment creditor's debt. And this is usually done through the auction process. And essentially, the court officer, who is the bailiff, will be the individual who is in charge of seizing the execution of the movable properties. And then afterwards, they will repay the judgment debtor itself of the amount that is outstanding in the judgment debt. And also, it will include the current rate of interest until the time the judgment debtor, until the payment of the seizure of the assets has been released to the judgment creditor. And also, in terms of the duties of the bailiff will also include a statement in the writ also to the judgment creditor to say that there's a certain amount of the judgment that has been endorsed, and also of how the bailiff has executed the whole process of the writ and seizure and sale, and then it forms a part of like accountability to the judgment creditor as well. So the writ is essentially a direction to the bailiff in this mode of execution of judgment. And next, I'll be talking about this case. Some of you may know of Datuk Sri Vida. It's been quite a big news recently where she has defaulted and owing a contractor she engaged to refurnish one of her properties that she owns, and she has owed or is still currently owing the contractor about up to 1 million ringgit. And thereafter, the judgment creditor has gone to court and obtained a monetary judgment, And then the court actually said that she has to pay the debt by a certain time. However, Datuk Sri Vida, she has failed to do so. And that's why they proceeded with the writ of seizure and sale to enforce the monetary judgment. And this case is actually still ongoing. And the court has currently given Datuk Sri Vida more time until January for her lawyers or the court to identify the ownership of all the assets that were seized, to identify as to whether those assets are legally and equitably or beneficially owned by her so that they can seize it. And then I will proceed to speak on the pros and cons of the writs of seizure and sale. Essentially, it is a good or recommendable mode of execution if you are aware that the judgment debtor has many assets or has assets that has value, high value, and it is able to pay off your debts. And also, it is a quicker way than some other enforcement actions that were mentioned by Alyssa, especially if you are aware that the assets are easily located, and in that situation, yes, writ of seizure and sale would be recommended. And next, assets are seized and sold to satisfy the judgment debt. And then afterwards, the creditor will receive the payment. And then unlike other enforcement mechanism, there is no uncertainty as to the end result, since the assets will be sold and then the money will be received by the bailiff, and then the bailiff will give that money to the judgment creditor. But on the other side, there is also the cons of writs of seizure and sale, where there might not be sufficient assets belonging to the judgment debtor to cover the debts, and the assets are not worth much, or there are assets that are mortgaged or hidden. So in those situations, it would be tricky to use this mode, and it might be more recommendable to use Garnishee proceedings or the other methods that were mentioned. And also, it's also costly and ineffective enforcement method if there are no assets to seize, and if the proceeds from the auction are not sufficient to cover, you might not be able to recover little or to no amount to your debt in general. And also, since the bailiff is also involved and you're involving the court in this process, and there's also the auction proceedings, there are all these additional costs that will be involved in this mode of execution. Next, I'll be speaking about bankruptcy and winding up proceedings. Generally, this proceedings is not a form of execution of monetary judgment. It's because it's not based to initiate this proceedings. You don't need a monetary judgment, but essentially is based on the inability of the company or the individual to not pay you. So I will first speak about bankruptcy, which is a proceeding against an individual that can be made bankrupt through an application of a court order. So there are two ways to go about. It's either a filing of a creditor's petition or a debtor's petition. However, in law, there is a minimum of 100,000 that has to be outstanding in the sum for you to initiate the bankruptcy proceedings. And now I will go through who is a debtor. So before a person becomes a bankrupt, you would refer to the person as a debtor. But in law, Section 3 sub 3 of the Insolvency Act defines a debt as someone who has committed or has done an act of bankruptcy. And that individual or the debtor has to be either in Malaysia or resides in Malaysia or carries a business in Malaysia, or through an agent through that business, or is part of a firm or partnership running a business in Malaysia. And also, a debtor is deemed to have committed an act of bankruptcy in any of the situations that is listed in Section 3 sub 1, which I will go through. And the most common acts of bankruptcy is in the situation where he files in the court a declaration of his inability to pay his debts, or he presents something called a debtor petition to show that he initiates a bankruptcy against himself. Alternatively, if he gives a notice to any of his creditors that he has suspended or that he is about to suspend payment of his debts. A third situation is that if the creditor has obtained a final judgment, which means that there is no appeal against the monetary judgment, then he can file a bankruptcy notice under this act, requiring the judgment debtor to pay that sum that is owing to him within 7 days after service of the notice. So that this 1, 2, and 3 examples of what the law sees as an act of bankruptcy. In addition, the law requires that for any individual who obtains a monetary judgment, if you want to file a bankruptcy afterwards, you need to initiate within 6 years. And the bankruptcy notice must be personally served under the rule. And if you're unable to do so, the court may order a substituted service to be effected. However, you need to go through in chambers and you need to request to the court that you are, and to show to court why you are unable to personally serve to the judgment debtor. And then it's up to the court to see whether they accept your substituted service. And if you fail to do so, the court would consider that as bad service. And the notice of bankruptcy would not have been recognized as served in the eyes of the court. Okay, moving on, I will be speaking on compulsory winding up, which is a winding up proceedings against company. So the difference between bankruptcy is that bankruptcy is against an individual and winding up is against a company. So in terms of compulsory winding up, the court will issue a court order to wind up the company, but this is only after you have presented a winding up petition to the court. And there are a few parties that can do so to file this petition to court to wind up the companies. That is either the company itself or any creditors, includes a secured creditor, unsecured creditor, preferential creditors, and also the liquidator. And in terms of the grounds for the winding up, it says that actually there are multiple winding up grounds, but the most common ground for winding up is when the company is unable to pay its debts. And there is also a requirement, a threshold that it has to be 50,000 ringgit in debt for you to initiate the winding up proceedings. And how the court would recognize or has established that someone has, or the company has been unable to pay its debt is if any of these situations occur. So when the company is indebted in a sum exceeding the amount, which is the 50,000, and also the creditor has served a notice of demand either by him or his agent, and requiring the company to pay the sum, and this has to be done within 21 days. Or the execution of processal of judgment, so which is like the other modes of execution, which is like garnishee or writs of seizure and sale, where it fails, then you could still proceed to wind up the company if you would like to do so. And alternatively, it could be a satisfaction of the court that he feels that the company is unable to pay its debts and he allows the winding up proceedings to go ahead. And I will sum up the pros and cons for bankruptcy and winding up. Essentially, after you file the proof of debt in the insolvency department, they will look into the company's assets, and then afterwards they will liquidate the assets, and then they will distribute the monies and everything to the creditors in terms of their priority. So which is for the secured creditors, and then to the preferential creditors, and then only to the unsecured creditors. So in the situation where you are an unsecured creditor, if the money has dissipated or has been distributed and it has been like to zero, and you have not received any money, winding up proceedings would not be favorable to you in that situation. So that is one of the cons mentioned. And also winding up proceedings would incur significant costs, is because the judgment creditor would need to bear additional legal fees to get this court application to go through, and also the service of the winding up notice and the bankruptcy notice. In that sense, you would also incur additional costs for that. And ultimately, it is depending on your case. It's a fact-to-fact basis as to whether the amount that the company has, the assets after it's liquidated, would be able to cover up your debt or not.
Thank you, Amanda, and thank you, Alyssa. We will now take questions from the participants. I will read out the questions, and one of our speakers will take turns to answer your questions. Okay, the first question is from Lim Info. Question is, are you able to do a garnishee application if you only know which bank the JD uses, but you do not know the account number?
Yes, so if you do know the bank of the JD, but you don't know the account number, it's fine, because the Garnishee Bank will confirm whether the JD has an account with them and will inform how much is in the account, because they would need to freeze the account. So you don't need the specific details of the account number. Just if you confirm that that is the bank that they have, then it will be fine as in, if you are able to identify the correct bank, then it's fine, because the bank will be the one confirming the amount in the bank and whether there is an account, the JD does have an account with them.
Okay, now we have another question here. Okay, perhaps Amanda can take this question. This is a question from Anonymous. The question is, the JD, the judgment debtor, paid the judgment sum but refused to pay costs. How? Can he claim interest on costs? And if so, what is the interest rate? Amanda, would you like to take that question?
Yes, the interest is payable for post-judgment interest. The interest rate for that would be determined by the Chief Justice from time to time, but the current rate for the moment is 5% per annum. And also you could issue a letter of demand to demand for the costs first before you proceed to the court.
All right. Thank you, Amanda. We have yet another question. I think perhaps Alyssa can take this one, yeah? The question describes the audience situation. It's from Anonymous. I have a situation where I'm trying to collect the costs awarded by court. I filed JDS, judgment debtor summons, but before the hearing, parties agreed to a payment schedule and entered into a settlement agreement, signed and stamped. The debtor paid a few months and suddenly stopped. When asked, the debtor, who is the director of the company, and the company is the actual debtor, the director says the family has medical issues, needed money to pay for hospital, asking to stop the payment for half a year and continue in June 2025. What can be done in this situation if I disagree and do not accept the excuse?
Okay, thank you, Manwei. I think in this instance, since the JD failed to pay according to the payment schedule, you can enforce the settlement agreement through a civil suit. But it also depends on the settlement agreement, whether there is specific clauses in the settlement agreement regarding, what would happen if there is a default. But in this instance, it would lead to enforcing it via a civil suit for breach of the settlement agreement, since a JDS was not done. And this would be different if it was a consent order. That would be a different matter entirely, because then you would have to enforce the consent order. But since this is a settlement agreement, yeah, it would be civil suit for enforcing it through a civil suit for breach of settlement agreement. So, but you would ultimately need to go through the terms of the settlement agreement.
The question comes from Lim Info again. Which legislation governs the auction processes in the WSS, Writ of Seizure and Sale? What are the exact auction processes? And is the National Land Code 1965 provisions applicable for the auctions? I think since this is just a short Q&A session, we will not be going through the exact auction processes, but maybe Amanda can touch briefly on the applicable statutes.
Essentially, at least for the purpose of this talk, we only would cover movable properties, and for that case, the rules of court would be the governing legislation for a writ of seizure and sale for movable properties and also chattels in Malaysia. However, yes, the National Land Code is applicable for immovable properties, but it's not under today's talk and is handled by a different team. So if you do have any inquiry about it, you could reach out to us for that.
We have another question here from one Chan Chin Chai. He's asking, didn't the government reduce the bankruptcy limit to 50,000 ringgit after the MCO was lifted? Perhaps Alyssa could help to answer this question.
Yes, during the MCO, the government did increase the limit to 100,000, but it has not been reduced to 50,000 back again after the MCO was lifted. It is currently still 100,000 as per the Insolvency Department's website. So far, it is still 100,000. That's why it would be a bit difficult to file bankruptcy, I would say, if you have debts, if the debt between you and your debtor is less than 100,000. So maybe you can try and consider other forms of execution.
Question from Anonymous. May I please ask which execution method is the most effective for enforcement of maintenance payments in divorce cases?
Okay, I can answer this. Actually, for areas in maintenance of divorce cases, for enforcement of maintenance payment in divorce cases, I would say that if the husband or if the ex-husband or the person who has to pay the maintenance has been defaulting, but you have contact or where they are, I would say a JDS is the quickest way to get one. But if the ex-husband or the person who has to pay the maintenance is uncooperative and would not want to attend the hearings, then maybe you can do a Garnishee application if you know that they have money. So it depends on the situation of the debtor or the person that owes the money to you. So, but we have had cases of people claiming for arrears of maintenance. So it is something that is possible to be done. So maybe upon further consultation and things like that, we can try and discuss, but it is possible. Yeah.
Right, thank you, Alyssa. We have a question here from anonymous. Company ABC did not pay his employee, Mr. CDE, the arrears of salaries to the amount of 150,000 ringgit. Are we right to say that Mr. CDE need not have a final judgment in the industrial court or high court or other applicable court before initiating a winding up application in the winding up court?
Okay, I think I'll take this one because from what I understand, employees who have arrears of salaries that are unpaid from their employer, they are considered as, I'm pretty sure it's preferential creditors, or it's either secure or preferential. I'm pretty sure it's preferential creditors. Please correct me if I'm wrong, but they are high in the priority list. So yes, you can proceed to initiate winding up applications for the company. And if the winding up application is successful and the company is liquidated, then you as an employee with arrears of salaries will be high on the priority list to recover the sums of your salaries. So yes, I would have to say that you do not need a final judgment, since I think Amanda also said that it's just a procedure or a tool to state that this company is unable to pay their dues. So yeah, you don't need a final judgment from industrial court to commence winding up proceedings against the company. And if you do commence winding up proceedings, I would say that as an unpaid employee, you are quite high on the priority list of creditors.
All right, I think time is almost up. So thank you, Alyssa and Amanda, for your insights. Before we conclude, I have announcements to and accountability from a legal perspective, which will take place on 8th of January 2025 at Wednesday afternoon. Please do take note of the website address stated in this slide and to sign up for our upcoming talk, which would be in January 2025. Secondly, please do fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Please do follow or like our social media accounts as stated here. If you'd like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box, and you could also scan the QR on the screen here. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.